All right, so thank you for having me here today. It's an honor to speak here. I was really excited when I got the opportunity to do this. And I really just wanted to kind of share this framework that I have been working on. We have been working on at TrueCut for a little bit now. And I think it's a nice kind of alternative approach to traditional pathways. And it's kind of just basically out of necessity, especially here within the United States, especially for sure. So cannabis, it's a crop unlike any other. And I say that I don't consider it a biological enigma or anything like that. Modern research tools are certainly applicable to cannabis, but just because of its history and its culture and legal status, it's been largely hindered from having access to those type of research and tools. So again, it's been largely shaped by prohibition. A lot of work has been done underground in an illicit nature and things of that. And because of such, one, we're kind of excluded from traditional agricultural kind of IP systems, PVPA, Plant Variety Protection Act here in the United States, and things of that nature. And so cannabis, just the culture kind of developed its own way of working and of just kind of operating out of pure necessity, right? Little documentation as far as breeding programs are concerned. If you keep extensive records, right, that's incriminating evidence that could be used against you and things of that. And so because of that, we've largely within Canada have relied on strain names, right? So Blue Dream, Durban Poison, things of that nature. And that really is kind of the crux at which cannabis has operated largely, is just names, and largely based on what we say here in the States, a trust me bro basis. It's just taking someone completely at their word without any other evidence or support or documentation or anything like that. Okay. And so when I do say cannabis for today, I am specifically talking about high THC cannabis, so like type 1 or just specifically marijuana. Okay, so not talking about fiber hemp or seed or anything like that. And so another thing with cannabis is it is absolutely fast fashion. I keep hearing this phrase being thrown around a lot as of late, and it's completely true. Market dynamics in cannabis, especially demand, can just absolutely explode. Currently in the States, we have a strain called toad venom. It's actually a cut of Becky was the original name of it, but toad venom has kind of just soared in popularity. Demand is through the roof, and this is all literally on a month time scale. So we're talking 3 to 6 months here that this has happened. And really, cannabis is unique in that regard, right? No one's really beating down the door to get the latest variety of apples or zucchini or whatever it may be, right? So the market happens, it moves very quick in cannabis. And when we start comparing these timelines with that of conventional IP platforms, right? So whether patents or plant variety protection with the USDA, there's a huge mismatch here, right? So we're talking about dust trials. These are field trials that take years to do sometimes. And then even just if we go the patent route, so here in the States, you can actually get a patent on a plant, and then that would then go through our patent and trademark office. And that can take years, right? When I worked for an IP firm, you're looking at applications and priority dates and things like that. And these things sometimes span years and can take a ridiculous amount of money to continue to pursue it. And so this is kind of a huge mismatch between cannabis specifically and kind of these traditional IP systems that we usually work towards. So for example, say a breeder has this new strain that they've developed. There's massive market demand for it. But they don't want to release it because once it goes out into the wild, so to speak, God knows what's going to happen with that cut, right? So you can just hack a cutting off a plant and that now walks out the back door. And this happens. This happens all the time. This is kind of the norm within cannabis here in the States. And so we need breeders need a way to kind of protect themselves. So if they just send it out the door, they can kiss any type of protection really goodbye. It's out on the open market, the open domain, as it's referred to, and you've just pretty much missed out. So if a breeder wants to move quick and spread their product, their strain through the market, they really can't do that in a protected manner. And they're kind of just left either lose your protection and make money, or don't make any money and retain your work. So it's not necessarily the most complimentary trade-off. So again, when we're looking at traditional IP pathways here in the United States, we have the PVPA, again, the Plant Variety Protection Act. And then we also have utility patents or plant patents. And so the PVPA, that is through our Department of Agriculture. That requires dust trials and things of that nature. But if you do utility patents or plant patents, that's a little bit different route. In my experience, kind of a lengthier route. It's usually a more expensive route as well. But also, while these two things exist in the US, high THC cannabis is explicitly exempt from any of this. You can do these protections on hemp and seed and fiber hemp types, but high THC cannabis is completely, it's not allowed as it sits. If we look at the EU, I'm not as well versed in EU policy, but my understanding, you guys don't have plant patents. High THC cannabis is allowed. However, it still has to go through these dust trials and things like that. And not only do the dust trials take time, they also cost money. And along with that, we also have application fees. So the application fee in the US for a PVP protection, that's $5,000 just for the application. And when I looked it up, it was kind of a relative similar manner in Euro for the CPVO as well. So again, kind of more money, more time up front, and that's kind of in friction with where a lot of cannabis breeders and operators currently find themselves. So, and then once we start looking at phenotypes, I think a lot of people are well versed with this kind of phenotypic plasticity, morphological plasticity. So if you were to take the same plant and put it into different environments, that plant is going to look different depending on what environment it was grown in. As you can tell from this is obviously not cannabis, but Arabidopsis. But just to illustrate the point here, nicely shown, we have Arabidopsis, the same ecotype, grown in 4 different conditions. So low light, normal light, high light, and then field conditions. And you can see that these plants look vastly different. And cannabis is no exception to that. If we look at this paper that I cited down below here, Campbell et al., they grew just kind of so vegetatively grown cannabis under different lighting regimes and different, so like fluorescence versus metal halide and things like that. And they found numerous differences in the morphometric traits of that. So while a lot of places rely on phenotype, it's not kind of the anchor. It is something that changes over time. This is a known thing. A lot of dust trials are, again, taking into account these types of things. We need to actually do genetic testing, genetic fingerprinting even, to get a more kind of static baseline anchor of identity purposes, right? And so have here in orange, like when you top a plant, right, when you alter the kind of morphology, the growing form of that plant, you're not changing the sequence, and it's right. Caveats aside, but the genetic signature is static for the most part. And so let's start actually like, what does a court actually need? And so I always frame this under the scenario of, say, a breeder has an agreement, a contract to provide, say, 500 clones to a cultivator, okay? And in that contract, it states you can flower out these 500 clones. You're not allowed to keep any material. You're not allowed to grow another round or anything like that. That was the original agreement, okay? And then say that cultivator then decides to keep a few cuttings as mothers or decides to clone that whole batch of clones to grow out yet another crop. And so this ultimately all just boils down to breach of contract. Or, okay, somebody stole someone's genetics, they're using them outside of the agreement, whatever. At the end of the day, this all boils down to like the question that the judge or anyone's going to ask is, can you prove that this plant is that plant? Like, are these the same plants? The person that received the plant material versus the person that provided the plant material. And we just need to be able to answer that question 9 times out of 10. That's generally the type of situation or scenario that we're going to be dealing with. And so really everything else underneath that goes to support the answering that question, right? So the documentation, what is the actual documentation we need to show that these two plants are the same? Along with that, so chain of custody, right? Provenance has to be maintained. We can't have any type of tampering from the sampling to sequencing, data analysis, all that things. And then also methodology, of course, has to be scientifically sound. And all of this collectively, what we're building up is this kind of evidentiary defensibility. So what is the type of empirical evidence and documentation do we need to show that this plant material belongs to this person? And so kind of these 3 pillars of defensibility. So one, that's just, do the fingerprints match, right? So if we were to take two different samples, do sequencing and compare those directly, are we going to get a match, okay? And then what I mentioned, chain of custody, right? So provenance can't be broken, so we need to have kind of documented transfer events with timestamps are huge when we look at like IP law and stuff like that. Timestamps, priority dates are very important. So kind of who was first, if you will. And then lastly, kind of this reproducibility. And this is nothing new to scientists, right? Reproducibility is kind of the crux of what we do. It's like we need to be able to reproduce our work. So could we run this same thing through our same pipeline? If we were to take our samples, run them through the same pipeline, are we going to continue to get the same answer? Okay. And so essentially what we're doing is we do this genetic testing, right? And we do kind of what we call doing a SNP or DNA fingerprint, okay? And then so once we get this kind of information back from sequencing, we can create what we call a dossier. So it's just highly detailed, like genetic report. And then that gets appended to the actual licensing agreement or contract that the two parties are going to sign. And essentially, we're taking the IP part of that, of the plant material, and we're like rolling it under contract law, essentially. So if we can't use traditional routes to protect our IP, we'll roll it under contract law. And at the event that we have a breach of contract, we can now pursue legal damages, okay? And once both parties sign these contracts or agreements, they're both bound by that. And basically that dossier, the appended document to that contract, is just kind of what I call the legal teeth, if you will, to give you some enforceability of like, I know what I have, I know how to test if you took what I have, and we can do that. And so it's kind of start looking at this kind of genomic framework, if you will. So like, how do we actually go about doing this, rolling this into contract law? And so again, all of this is based off of sequencing data. And as the old saying goes, there's more than one way to skin a cat, right? So we have a few different approaches. The first would be like STRs, microsatellites. And there's legal precedent for this, absolutely. When we look at like forensic cases and stuff like that in court of law, IP cases, things like that, those definitely have been used and are accepted within the court, within the United States. But honestly, as time goes on, they're becoming much less popular. Even third-party like sequencing labs that provide that service of doing this, STRs and microsatellites are kind of just falling out of fashion because they're just getting replaced with kind of new approaches, new methodologies that give us even a little bit more data for more resolution. Next up, which is kind of what I consider the sweet spot for this type of thing, is reduced representative sequencing. And so ultimately what we're going to do with this is we're going after SNPs, so single nucleotide polymorphisms. These would just be single base pair changes in the DNA, and we're going to look at those across the whole genome sparsely, right, reduced representative. And then we're going to compare those to see what kind of genetic evolutionary signal we can get out of that. And then if you wanted to, you could go whole genome. This obviously will give you the most resolution, but your cost starts going up. You're usually looking at several $100s per sample once we start doing whole genome. And at the end of the day, for just establishing identity and doing relatedness type stuff, whole genome is kind of overkill. I like to say it's like using a cannon to kill a fly. It's like you could certainly do it, but you don't need to go that route. And so we've kind of settled on reduced representative sequencing. We're actually using ddRAD-seq specifically, and that gives us all the information we need to create a fingerprint and one that's unique, okay? And so with this SNP fingerprinting, these are kind of the things we're able to do with it, right? And so within this legal agreement kind of framework, licensing agreement framework, we're not necessarily establishing ownership, but rather identity, okay? So say a breeder has been working with their version, we'll say Chad's Durban, right? Can't say that I own the Durban name, right? However, I do control, hold my cut, my version, my variety, if you will, of Durban. And that's what we're actually protecting. So we're not claiming ownership in a really broad sense. It's just literally the plant material at question, okay? So just kind of to set that. And then relatedness and population. So by doing ddRAD-seq and using the SNP fingerprinting, we're really just using kind of phylogenetic or population genetic approaches, and we're kind of comparing this all sequences against all sequences, right? In phylogenetics, you don't have a standard or a reference sequence. You can include a more distantly related sequence or sample, and that would help you give kind of some perspective. If you were to look at a family tree, a phylogenetic tree, that would kind of help you, give you some orientation around things. But at the end of the day, we don't need a standard, right? It doesn't matter, do you have the original cut of Durban poison or ChemDog or whatever it may be. It really doesn't matter. We're still just doing this comparative approach without using any one reference, okay? And then legal uniqueness, and I included this in here, but this is, take this with a grain of salt, because you can claim it's unique all day long, but you're also never going to be able to compare it against every strain that's out there in existence, right? So you can only claim uniqueness to an extent of how kind of deep or thorough like the database is that you compared it against, right? So if your database has a size of 15, you don't have much strength to say this is unique. You have uniqueness among those 15 strains, okay? And so, yeah, the US kind of, this framework was really kind of just came by necessity, right? Kind of looking at, if we can't use these existing kind of traditional routes for IP protection, what can we do? How can we kind of make a new system, new framework, kind of look at this from a different perspective to utilize existing systems that are also kind of more suitable for cannabis? So this kind of just, it came out of necessity because we are exempt, as high THC cannabis is exempt from protection, okay? And then the other thing that's great about this is it's really fast, right? So you can do sampling. get that sequenced, and then run it through your analysis pipeline. This can all be done on the time scale of, if you're sequencing, if your provider's good, days to weeks. So this is an approach that can absolutely keep up with how fast market dynamics move and consumer demand. And we're not sitting around waiting months to potentially years on paperwork and things of that nature. This is something that can move incredibly quick. And then lastly, like, it's jurisdiction agnostic, right? So here in the United States, like, we get our sequencing done in the US, and so we can apply this methodology, this approach, to kind of everywhere within the United States, even within a specific state if we really needed to. But this could happen in Europe, in the EU, no problem. So you could have the sequencing done there in Germany, and then this type of documentation could be appended to licensing agreements and then be used. That same with Asia, Australia, wherever you're at. It really, truly doesn't matter where you find yourself. As long as you can get the sequencing done by somebody, you can do this. And so, yeah, just kind of sum all this up. It's like cannabis, for a multitude of reasons, is a really poor fit for kind of traditional IP protection routes. And so this is kind of a new way to approach it, right? And a lot of things go off phenotype, when you're looking at litigation. So in court case, phenotype kind of gets thrown out the window sometimes. It's because it is plastic, it does change. This includes chemotype as well, right? You can have you can have the same strain from the same mother plant, grow them in two different environments, and you're gonna get different cannabinoid interpreting profiles. Like, we know this. And so by using a genetic marker, SNP fingerprinting specifically, we don't have to worry about those environmental differences, okay? Yeah, traditional doesn't match. And then so basically this new framework of rolling these kind of what we're calling dossiers into contract law, it's a way to protect what you've worked on without having actual formal IP protection. And then again, we don't necessarily see this as going against traditional regulatory pathways. We kind of see this more as this is something you would just do along the way. If you were to do this type of fingerprinting up front, you would have all this empirical evidence that could then be submitted with your application for CVPO or PVPA, whatever the case may be, to kind of pursue those more formal protection routes. And so it's kind of just this kind of ecosystem that's kind of working with each other, and we're just trying to give breeders and high THC cannabis, like operators and things like that, give them a chance to protect their work, and give them something real and that's kind of defensible on day one, versus just kind of hanging around hoping and waiting for something to happen at the legal level, legislative wise. So, and with that, yeah, happy to take any questions.
Thank you so much, Chad, for that. Questions from the audience? I don't know if you can hear them clapping, but they're clapping for you.
Oh, okay, thank you. Yeah, I'm having a really hard time. My computer speakers aren't the best.
Yeah, don't worry. I will be taking some questions from the audience, and then I'll pass them on to you myself because you won't hear them when they talk, okay?
Okay, great.
Questions?
So I think this is more a law type question. For example, you got Durban poison and you have to characterize it. You say, this is the Durban poison, this genotype is the Durban poison, and somebody else say, okay, I've got the real Durban poison, and this is the real genotype. Is there any example of this problem? Because there is the problem that people say, this genotype is the real one, or this one is the real one. Is there any solution included in the contract, or you got any ideas or examples?
So the question is related to, tell me if I'm rephrasing it incorrectly, to the potential conflict that arises around the originality of a specific genetic and whether there is conflict to who owns that specific original.
It's more about the name.
Yeah, that's...
to the naming
Go ahead.
specifically, and whether or not you have already solutions in place within that framework for that.
Okay. We really don't. As far as coming down to like who owns the original, like if we want to talk like Northern Lights, Durban Poison, whatever, that's really hard to determine. And that is largely going to come through anecdotal evidence, right? And so the whole framework, the whole premise of this framework isn't to necessarily say, how do you protect what you currently have? And I would love, and I think there's a lot of us that would love to be able to answer who has the original strain, whatever. But at the end of the day, I don't see that as likely for cannabis, especially like high THC type, because again, a lot of it's going to be anecdotal. And then I'll even give you an example of specifically of why that's tough. Because so I recently was speaking with Kevin Jodrey. He's like a huge legacy breeder here in the United States. Like kind of everyone here knows who Kevin Jodrey is, or they've at least heard the name. And so specifically for the strain permanent marker, you will see that in dispensaries and people talk about, oh, it's permanent marker, but actually what it is that permanent marker is actually a pool of different plants. So it kind of, I don't remember if it came out of a seed lot or like breeding progeny, whatever it was, but there's not just one permanent marker, right? There's actually multiple, and they're all slightly different in their own regard. And this is the same thing if you look at, this is going a little further back, but ChemDog. So you have Chem 91, you have ChemDog, ChemDog 1, you have ChemD, and things of that. All of those seeds, those different lines, actually came from one just big bag of weed, and there just so happened to be, I think, like 12 seeds or something like that in that bag that he bought. And so it's really hard to determine like who's the original owner. Again, documentation is little to none at best. And then it's he said versus they said. So I don't know if we'll ever truly get to answer those types of questions. But no, we're currently not set up to answer that, and that's not necessarily something we really want to get into.
Thank you very much.
Yeah, hi Chad. Thanks for the talk. That resonated strongly with my business in particular, so really like what you're trying to do there. Yeah, and fundamentally it sounds like it's a contract with a snip fingerprint of your plant that you're selling on to someone. So it makes me think though, is that applicable to, must be applicable to all plants beyond cannabis then?
So the question is whether this snip technique is actually applicable to all plants or exclusively to cannabis?
No, we can apply this to all plants. That's the beauty of it. And actually at TrueCut, we've been thinking about possibly cannabis is our core market that we're focusing on right now just because there's such a huge need for it. And we want to help people protect their work. But no, this 100% could be applied to pepper plants, tomato plants, whatever. We aren't necessarily going after them at this moment because again it's just not the market we're after, but it absolutely can. So DD-Rad-Seq, it's fantastic for plants, especially for those which we don't have a genome for. So our CSO Anna Schwabi, she spoke here last year using these population genetics. So she did this with rare cacti here in the United States. So DD-Rad-Seq is excellent for plants that you don't have like a model species or a reference genome for. You can just still get this data, still run it through your population genetics, genomics, different softwares. There's multiple out there, structure, things of that nature, to where you can, still tease apart and look at these relationships without having a reference. So no, it's fantastic for that.
Thank you, Chad.
You're welcome. Okay. All right, I'll say, definitely. Thank you so much for letting me speak. definitely appreciate the invite, and hopefully in the future I can be there in person. So looking forward to that.